Hello, everyone. Welcome to the webinar today. We are so excited to have you with us. My name is Alexandra Alvarado. I'm the Director of Marketing and Education here at the American Apartment Owners Association. Today, we're going to be talking about estate planning. This is a pretty comprehensive workshop that's going to take you through the ins and outs of passing your real estate asset to your heirs. And that is obviously very important to do. You've all worked so hard for what you've achieved, and now it's time to start thinking about how to pass that along to your children or your heirs. And so we'll be covering all of that, as well as some asset protection strategies that come along with asset planning if you do it right. We have with us Noelle Bryce, who is an estate planning attorney with BarthCalderon. Hi, Noelle. And we have Paul Hitchcock with us as well, also from the BarthCalderon team. He will be helping us moderate this whole discussion today. But before we get started, I have a few housekeeping items. One is, of course, we are recording this whole thing and we will be emailing it to you tomorrow. So if you miss anything or you want to review or share this later with anyone, you certainly can do so. And also any slides that will be shared today will also be provided to you tomorrow in that follow-up email. Now, to start, I want to thank our sponsor today, which is MasterCard. MasterCard has helped us to create a new offering for AAOA members. So I did want to just go over that real quick. I'm sharing here my screen. Briefly, the AOA World Elite Business MasterCard is something that we designed to help landlords and property managers optimize their finances. So just to give you a little bit of background, the idea was for us to be able to design something for you all that would give you cash back on the things that you use the most. And I imagine today we might be touching on insurance. That is one of the categories that we covered in our highest percentage, which is 5% cash back for insurance. So that's becoming, unfortunately, a bigger line item on all of y'all's bills. So this will help you with that. Also, any repairs, renovations, maintenance, you get 5% cash back for that, and anything that you purchase on our website as well. And then for everything else, it's 2.1%, which is still really good. There's no annual fees. You don't even get your credit hit when you apply. And if you do sign on, you get a $500 sign-on bonus if you spend a certain amount within the first 90 days. So I wanted to just call this out because I do think it's an excellent card for landlords and property managers specifically. So if you already have something, this might be actually a good way for you to get a little bit more on those high ticket item expenses that you're probably experiencing, like those repairs and maintenance, especially if you use this for tenant screening. That's another way that you can get that 5% cash back. So to learn more, you can go to aaoacard.com, or you can email this email here, which is the MasterCard team that is managing this whole thing for you. So I'll leave this up on the screen just a little longer. And I'm going to also launch a poll question here. If you would like to receive more information about that MasterCard, I can email it to you, or we can have someone from their team give you a call. So go ahead and say yes, email me, yes, please call me, or no, thank you if you're not interested or you already applied. And then we'll go ahead and sort that out after the webinar for you. So the next part here that I wanted to share with you all is that as an offer today for the estate planning side of things, if you want to get a complimentary asset protection assessment, including an estate planning assessment as well, there is a link here to book your free call with an attorney on the BarthCalderon team. This link, I'm going to drop it in the chat for you all so you can book that if you want. We'll also have a poll question at the end, but I did want to bring this up now just in case any of you have to leave early. So I will drop this link in there, and this is a great way to get started if you have a lot of questions after the webinar as to your specific situation. A team member from the BarthCalderon attorneys will be able to reach out and help you with that. So I'm going to go ahead and end the share here, and I'll let Paul start sharing the slides for the presentation today.
All right. Thank you, Alexandra. Hello, everybody. Thanks so much for taking the time to be here. And I want to say a couple things before we get into Noelle and I and our interactive talk here. First of all, who the heck we are. I think it's always important to understand who the speaker is and why we're in a position to talk to you. So we're BarthCalderon. We are headquartered here in Orange County, California at this building. And we have been around for over 35 years. One of the first firms ever to do asset protection. Our founder and senior managing partner is Harry Barth. And we're an estate planning, asset protection, business planning firm with about 11,000 clients across the country. And our clients really run the gamut. We have a lot of families, a lot of wealthier clients, people who are just starting out, everybody in between. Certainly a lot of rental income property owners. We put on about 40 workshops a year, in person, online, to AAOA, obviously, one of the top speakers here, other apartment associations, business groups, all over the country. We're very big on education. It's a way for us to give back. And so there is very hot issues going on in estate planning and asset protection today, and we're going to get into this. So for property owners in particular, Noelle is one of our top speakers at the firm and does a lot of education. And so we're out there. Noelle is teaching. And as Alexandra said, for anybody that gets involved in any education we're doing, we do have the complimentary planning assessment. You can get one-on-one with Noelle. And it's great. We do that by Zoom. No obligation to do anything. And it's a chance for you to ask questions specific to your own situation. As you hear what we're talking about on this presentation, certainly we want Q&A as we go through this. Fire away. But also, if you want to get on the Zoom, Noelle will take a look at what you're doing. And the whole idea is to get you organized, updated, and protected. The link, you're putting that link out there. We also have the link on the slides. And Alexandra, are you going to get the slides out to everybody afterwards that we're sharing?
Yes, and the
Okay.
recording.
And the recording. All right. So let's get into this. I'm going to share my screen. Give me a second here. And we were working this beforehand. I think I've got the full screen now.
Oh, good.
Yeah, we had tech issues earlier on, I think. Does this look okay?
Yes, that looks great.
Okay. So Noelle, let's jump into this. Noelle, top attorney at the firm, Estate and Asset Protection Planning. First of all, let's get into the agenda, entitling for rental property, the different ways to hold title, best practices. What do we need to know here?
Thanks, Paul, and thank you, Alexandra, for the introductions and warm welcome. I'm really happy to be speaking to all the participants here and looking forward to connecting with you all in a more one-on-one session if needed. Great intro to asset planning and asset transfer is knowing, well, how are we initially owning the property? What is the title of the property? And I think in many regards, this gets overlooked or not thought of enough of the consequences that could ensue if we take title in an unintended way or recommended by someone. You should do joint tenancy, or you should get an LLC, or you put it in a trust. Okay, but why are we doing those things? And so titling is another word for ownership. It's whoever's on title is the owner of that asset. Whoever's on title can manage that asset, has the ability to make decisions regarding that asset. And if we have joint owners on title, they're typically equally able to do those things I just mentioned. So very important to start with a granular issue of who owns title and who is on title as the owner, because then that person is also the one subject to liability. So when we delve into the asset protection discussion of this, it's not just a matter of estate planning, who owns it and where does it go to for purposes of transfer, but whoever's on title is also the one exposing the asset to risk and is the one liable to pay back whatever liability comes their way. If they're on title, they're able to be subjected to liquidating that asset or to some degree, right, being the one that has to act, legally speaking, with regards to that asset. So we have individual ownership. You could be the only one on title, just in your individual name. Simple as that. Joint ownership can look differently if you have joint tenancy or if you have tenants in common. Those two things have joint owners, but they operate differently. Joint tenancy typically means everyone owns it 100%. So if one person dies, the survivor also owns it after that. Tenants in common means you're actually splitting up the asset in how much ever percentages. If it's two people, tenants in common, then 50-50, three people, a third, and a third, unless it's delineated somewhere on title. And then, of course, with that discussion point is, well, what happens if one or more owners pass away? So for purposes of protection of the asset succession, that piece isn't planned for if the people are just on title. And for purposes of wealth transfer, it's not clear where those assets are going other than probate. We'll talk about probate later today. And then, of course, you could take title in the name of an LLC. Then we'll see through there to who the members of the LLC are for purposes of ownership. And of course, LLCs provide that additional protection, which we'll also get into. And then, of course, you can have trusts own title to properties. It can be a land trust. It could be an asset protection trust. It could be a revocable living trust, your typical family trust. And then we're, of course, seeing through to the trust to see who the creators of it are, who the beneficial owners of it are for purposes of understanding who can control the asset, who benefits from the income, etc.
Great start. So I have some questions I want to clarify on this, Noelle. It's for the benefit of everybody, because titling is huge, and we get about 7-8 hair on fire calls a week from people that are having liability from tenant liability, something happens with a tenant, or outside liabilities. And I want to talk about inside versus outside here in a second. But with the hair on fire is because there's liability, they don't have any asset protection, and now they're nervous. And what we hear a lot, I want you to clarify this, is a living trust. People think a living trust is an asset protection tool. So they'll call up and say, I think I'm okay because I have my property in a living trust. Can you explain why that's not the case?
Yeah, absolutely, Paul. I'll bring it back to the word protection, because what I typically hear as an important but misused word is my trust protects my assets. Okay, but how does it do that? The living trust protects from probate. That's really all it protects from. It protects from those assets going to the probate court or transfer of title court process after somebody dies. That's really all it's protecting from. The living trust is just an extension of those who created it. Legally speaking, the trust does not protect the assets from creditors, liabilities. It is just an extension of the person who created it because it's revocable, it's living, it's basically passed through to them. So yes, we're protecting, right, so to speak, the assets from probate, but not from any liability or exposure during the lifetime of the creators of the trust.
So if you have the LLC, what I want to talk about is the inside versus outside liability of that rental property owners are exposed to. And then if you do have the LLC, how to properly set that up and how does it interact with your living trust? So first, LLCs, why have it versus owning it in your individual name or your trust when it comes to inside and outside liability?
So we think about inside and outside liability. We're thinking kind of flow of traffic. Where is the liability coming from? Where is it going to? And who is it attaching to? So if you have an entity called an LLC, it's a limited liability company, what it's doing and what it's designed to do is stop the flow of traffic from anything coming outside of the LLC. So I got a rental property making some income inside of my LLC. If I do anything unrelated to that in my outside world, car accidents, issues on your home, property, personal issues, unrelated business issues, there's that liability, that flow of liability traffic can't make its way into this LLC you've created for your rental property. So it's protected from outside liability. Now, inside liability is that flow of liability traffic that's inside of the LLC, and that has to do with the nature of the property that's inside the LLC already. So you have a rental property in there. We're talking about anything related to that business to be slip and fall. It could be lack of management. It could be eviction issues, landlord tenant issues, anything that's coming out of and related to the operating business and the operating entity. That's inside liability. And that inside liability, it's pretty fair game for whatever's inside of the LLC. So if a tenant slips, falls, sues you, the LLC as the landlord, they are able to fairly negotiate their judgment against the equity of whatever's inside the LLC. But if we structure the LLC properly and maintain it properly and respect the integrity of it as a separate business, that tenant should not be able to break through the LLC and go after all your other assets. And for similar reasons, if there's an outside liability, a well-maintained, well-structured LLC maintains its integrity and shields your asset from outside liability breaking in and getting the asset inside the LLC. So we have that flow of traffic. You can strategically plan so that your assets are not exposed outside of the LLC. And of course, with insurance and other things, strategically plans that your assets inside the LLC are also fairly mitigated in terms of exposure.
And so I want to give a real life example because my team, we're the ones that accept these hair on fire phone calls and get them doled out to the attorneys. And two examples just to illustrate inside versus outside liability that came fairly recently to the firm is on the outside liability as a real estate agent, Northern California, and selling very expensive homes. And there was an issue with a multi-million-dollar home she sold, floors buckled or something, Brazilian cherry wood floors, whatever it was. There was a major lawsuit. So the purchasers of the house sued her personally. She's married, kids, husband owns a business. They also have their own rental properties. This liability then started going after all their assets. And this is the outside liability. So they started looking at the rental properties and seeing what was going on there. The husband got very nervous. His business was impacted. Outside liability, right? And this is the traffic you're talking about that's coming into the rental property. And the other inside liability, we have landlord attorneys, and we've seen a lot of mold cases, for example, where a case came in, mold in the apartment, and 20-year tenant, and they went after the landlord, there was mold, cleaned it up, health department said looks fine, and he said I'm fighting this thing. They went to court, he lost, and it was a $3.5 million judgment against him for attorney's fees and the other damages and no asset protection. And this thing was breaking out of the rental property because there wasn't enough equity in that rental property to cover the liability. The judgment started going everywhere. All is looking at his other stuff. So that's inside outside liability you're talking about. And then I want to ask you too, so a lot of people hear about LLCs, Noelle, and they say, oh, you just bang one of those out. What really matters there is that thing's got to work if the liability happens. It's like earthquake insurance on your house. You hope, you have paid the premiums, you did it right when your house is rattling. So with the LLC, how are those things picked apart? What if there's a liability, what goes into making sure that thing works well?
An LLC is an operating entity, right? It's given authority by the government to operate as a business, and you get the protections if you operate as a business. So if you think of it that way, yes, I can have a simple articles of an organization. I can get that off the Secretary of State website, and then I can open up a bank account and boom, I'm in business. Okay, but the reality is that's not how a true business would act. That's not how a true business would look. In fact, the formalities of walking and talking like a business would require that you have operating documentation, that you maintain the integrity of it as a business separately from your individual checkbook and checking accounts and savings accounts, that when you are conducting business, that you are acting as the manager of the LLC or the member owner, depending on how the business is structured, and you're keeping separate accounting, and that those operating documents are reviewed. You may decide to have minutes or decide to have a vote, even if you're the only one in control, is still having something memorialized in writing that a big decision was made on behalf of the business, right? If you are a truly operating business, you don't just walk around making your own decisions with no record keeping. You would keep records, you would keep minutes, you would consult, you would do research, right? You would do your books. And so the same applies, and specifically and more logically for rental property owners, they have to do these things in order to understand the health of their business. That's the same thing you would do when you have an LLC. You want it to be have a strong integrity and its separateness from you, be healthy and mitigated from liability, which includes getting proper insurances, making sure that you are following up with all the laws and regulations that could apply to your particular property, and keeping all the records that need to prove that you're not just running it like you with the sham name of an LLC. Because when a liability hits, it's not that whether or not you kept minutes is going to be the straw that breaks the camel's back, but it's certainly one of the factors that will be used against you. Did you keep a separate account? Do you made this big decision to get this loan or buy this insurance? How did you do that? How did you sign the documents? Were they signed just by you and the money just came out of your personal account? Or was everything truly kept separate as if an operating business would? And so those small granular facts, Paul, come into play, and they become weighted pretty heavily when they all start stacking up. And now it becomes clear to the other side that you're not really running a separate business. It's just you under the name of an LLC that you just created. And so the government at that point, even though they allowed you to operate under this entity, along with the state laws that say, hey, you're not maintaining it properly, wouldn't protect you as much as they could.
Yep. Great stuff. Question here. Michelle's asking, thank you, Michelle. If someone has a rental property with a trust, then can they not have an LLC for this specific property or this and other rental properties, or both LLC and trust?
The really neat thing, and great question, Michelle, the really neat thing about trusts is that they are designed to own property, and they don't have to own the property directly. They can own interests, membership interests in an LLC. They could own an entire corporation. And so the way to think about it is that the trust would be the top of that ladder, and everything kind of folds underneath it. So kind of like a Russian doll scenario, the trust being the Russian doll on the outside and everything else underneath it. So the trust can own the membership interest of an LLC, that LLC then owns the actual real property. And so that what we can accomplish there is asset succession planning, because we would already say who the member owner is of the LLC, which would be the trust, which then tells us where that asset would end up should the member owner pass away, or we have some kind of succession plan for it. So it doesn't have to be a one exclusive decision. Do I have an LLC or do I have a trust? It can be a combination of both. And in the best of worlds, if we're doing asset protection, it might be an asset protection trust, or it might be another LLC that owns your LLC, the holding company, all kinds of strategies we can utilize. But at the end of the day, we do need to make sure everything is organized and passes through, for purposes of succession, passes through some kind of trust entity to transfer the assets post passing away.
Great. Steven's asking, thoughts on reducing exposure inside the LLC?
Yeah, inside the LLC would mean how you operate your business from day to day, and a little to piggyback on what I just said a little bit with regards to maintaining your LLC and the integrity of it as a true business. So proper record keeping, bookkeeping, making sure it stays the proper status with the Secretary of State. And then, of course, the requisite insurances that you would need to do business, that would be the best. And of course, following the laws that apply to that asset. Sometimes there's local laws that are changing, and being proactive about mitigating any of those risks if you need to get inspection reports or other types of maintenance of your existing asset. That would reduce exposure because you're reducing the liability itself. Otherwise, you are operating a business. So there's going to be some liability inside of your business.
Yeah, and I've heard you talk about too, and Tanya, I'm going to ask your question a second here. I've heard you talk too, jurisdiction matters. Just because you own a property in California doesn't mean you need a California LLC. It's a big deal. Again, if something happens, jurisdiction matters.
Yeah, absolutely, Paul. And that's a great point. It touches more on an advanced topic of asset protection, but
Yep.
I think our participants here are ready for that, considering they're pretty seasoned business owners themselves. But the way to be strategic in a liability event is to make sure your LLC is properly structured. And so what that means is you can have, and you should have, right? If you have California real property, you should have a California-based LLC. But what we can do is we can be more strategic about where the LLC is initially registered. So in many cases, we would recommend Wyoming or Nevada initially registered LLC, because then we can make the argument that we're latching on to those state laws for purposes of applying those laws to the facts. So if there was a liability, we could say, well, the Wyoming or Nevada laws applies to this LLC. Therefore, judge, or therefore opposing counsel, or whatever the case may be, you are not able to have a charging order and break through this LLC and force the member to liquidate the assets. Where in California, they would be able to do something like that pretty easily through simple court procedures. And especially if it's a single member California LLCs don't have as much protection and that you would expect them to when things actually hit the liability stage and we're talking negotiating with the other side. You realize, well, then that California's laws are not ideal. And so jurisdictionally, which is what Paul's bringing up, the jurisdiction of a California LLC would be California. You have to go to California court. California law has to apply. Okay, but if I created my entity initially in Wyoming or Nevada and then registered it as well in California, I can make the argument then that the jurisdiction, the law that should apply to my conflict or my fact pattern should actually be Wyoming or Nevada. And in that case, I've added another token on my negotiating side of the table because I've made it a lot harder now for the creditor or the opposing side to say, well, I'm just going to go to a California court, force you to liquidate these assets. So now we have a conflict of law, application of what jurisdiction is going to apply, and we can definitely use that to our advantage.
Oh, that's awesome. That's great. We're getting a bunch of questions. We love it. Does the deed of the rental property have to be in the name of the LLC? What if your principal home is still with a mortgage? How does this document affect the living trust?
Okay, great questions. Somewhat overlapping, but also distinct. So the deed of a rental property absolutely needs to be funded or retitled into the name of the LLC. So the LLC is the owner on title. Remember, that was the first thing we talked about in today's meeting. Who's on title is the owner. So you need to confirm for operating businesses, operating purposes and asset protection purposes that the LLC has authority over this asset. It is the owner. Otherwise, if it's outside of the LLC and you're just individually still making decisions over it, we have not crossed over to the asset protection land, right? We have not stopped the flow of traffic because we're still in the land of, well, I'm still acting over this property as an individual, but I have this LLC collecting rent. So there's a discrepancy there. When it comes to primary residences, typically I advise at least to not directly put them into LLCs because you lose the owner occupied status.
Right.
which affords you a lot of other benefits, right? It affords you capital gains benefits. It affords you a tax basis that you maintain, and it's a slight break on that as well because it's your primary. You lose what's called the homestead exemption. The homestead exemption is a certain number, usually around, if you're in California, Southern California, somewhere between 400 and 600 is protected of equity in your property. That's great news. It means that no matter how bad things get, you could protect at least that much. So if you take that property, put it into an LLC, it can't also be owner occupied. So the argument that it's still your primary is kind of harder to make. And we also lose out on some of the assessment issues and capital gains issues. So the better strategy for a primary residence, typically what we'd recommend is a land trust, which is still a revocable trust. It still passes through to you as owner. And then we strategically make sure to assign the beneficial interest in the land trust. In other words, who's actually the owner of the land trust by as a beneficiary. We take that and we assign it to an LLC. And so we put up a little bit of a higher wall than it otherwise just being in your name or the name of your living trust, and puts us in a better strategic standpoint if there is a liability. There's other strategies to do as well, like stripping the equity from your home and other things. A little bit more advanced. It has to make sense for your situation. But typically speaking, your title of your primary residence can stay in your revocable trust, or you could utilize a land trust.
Yeah, that's great information. And we do a lot of those, the asset protection tool for the primary homes. That's a question that comes up a lot. Do I put it in an LLC straight away? No, for the reason you just mentioned. One of the questions I want to get to the next section. This is awesome. People love you, Noelle, with these questions, so it's
I love you
fantastic.
all too. I love you too. Thank you.
All right, Ben, good one here. We have rental properties under LLC and have LLC accounts separate and everything run as an LLC. Some other attorney is asking us to assign the LLCs to our living trust for asset protection. Will this protect against liability inside the LLC?
So if I'm understanding this correctly, the LLC has its accounts, and then there's a recommendation to assign the membership interest into the trust.
I guess an attorney asked us to assign the LLC to our living trust for asset protection.
Asset protection exists within the LLC itself. The only additional asset protection that would be acquired is if the membership interest was assigned to an asset protection trust, which is not the same as the revocable living family trust. So I think based on what is being presented to us, Paul, I'm not sure if,
Yeah,
these can get lost in translation and I don't
right.
want to make any assumptions, but a revocable living trust is not going to additionally protect the asset. Remember, we talked about protection only from probate being used in that scenario, and I know a lot of practitioners use that word as a nice attractive call to action, which is great, but it's a misnomer because it's not protecting from creditors if it's in a revocable trust. It's protecting from the probate court process, which is asset protection later
Yeah.
because there's probate's expensive, there's conflict. We end up spending a lot in litigation if there's conflict. So yes, it is a type of asset protection. In other words, we're not spending a bunch of money in probate, but in the typical sense, we say asset protection, we're talking about currently mitigating liability and better positioning you against an active current creditor. Not current creditor, but anticipated creditor.
Okay, and this quick answer here, best state for an LLC, you had mentioned Wyoming, Delaware. Any others you would recommend?
Depends on, what we're doing, but typically Wyoming, Delaware, Nevada, sometimes South Dakota. It really is a more of an art, Paul, in making sure we strategize based on the individual client's needs, based on their operating businesses, the nature of their assets, the nature of where the properties are located, and just overall the overall plan for succession to those assets. So there's not a one answer to everybody's situation, but those are the laws that are laws of the states that are more advantageous and better position the business owner for that jurisdictional type of advantage.
Got it. Tina's got a good one. Is it better to put each rental in a separate LLC or several rentals in one LLC?
Awesome question. Yeah, very good question. I would encourage you to think about how an LLC in its operation, and what is it doing and what is it protecting from? An LLC puts a shield, right, over whatever assets are inside of it. But if there is a liability related to the assets inside of the LLC, everything in the LLC is fair game. In other words, if I put four properties in an LLC, A, B, C, and D, any liability related to A can latch on to the equity from B, C, and D.
Mm-hmm.
And so one of the analogies is putting the, fox in the hen house or some kind of other analogy. In other words, you're putting all your eggs in one basket. Whatever egg or Easter analogy you want to use, the reality is the golden rule is if we want to mitigate to the best advantage position, it would be one LLC per property, right? Because we don't want to unnecessarily expose one property's liabilities to another, especially if they're not equally weighted. You have a 300K condo and a $2 million apartment building. You don't want to put those together because your 300K condo liability can latch on to your $2 million apartment. And so, yeah, the golden rule is one property per LLC, but we also understand that you're busy, you have a lot of properties, it doesn't make sense maybe to have numerous, kind of over numerous amounts of LLCs. So we can strategize surrounding what, properties to couple together, how many LLCs to use, fortifying the protection in other ways. So that's a discussion for sure for each individual client and their goals.
Yeah, yeah. As you get into this, as it gets more complex, this is a great chance to get one-on-one with Noelle offline on a Zoom. She'll get into the weeds of your own situation. We'll take maybe one or two more questions before we get to the next slide. I just want to keep hitting these because obviously it's an area of interest. Mark, thanks for this. I own rental buildings in the name of an LLC. State Farm holds the fire and hazard insurance policy. I self-manage the rental buildings along with my wife. We own the LLC 50/50. So a two-member LLC. Would it be advisable to add our personal names as owners of the LLC and/or property managers as co-insured, or would that commingle our personal names with the operation of the LLC?
Yeah, it's really interesting how the insurance market works. And as much as we can try and separate for purposes of liability, my understanding is the insurance industry is looking through to the individual owner to be added on those policies, and you would add the LLC as additional insured. Unless you are fortunate enough to have the LLC as the initial insured, then I don't see why it would make sense to add yourselves on as additional insured, personally speaking. And these are just some of the granular facts that could be used to argue, or the other side to argue, that there's been a commingling, right, or some type of lack of separateness. But insurance is just a harder dynamic, especially with what we see happening in California right now, and some of the difficulties in the market of even having a small change to the insurance policy. So I don't know, Paul, if you've come across this recently, if you wanted to add any additional insight on this question.
Yeah, I'll say that on the insurance goes hand in hand, sort of, glove in hand connection between the insurance and the asset protection. Insurance is your first line of defense. That's got to be done right. and it is tricky. So we have an insurance expert, part of our extended team, Jerry Connery. I think he's done a workshop on here before, Alexandra. But if you take advantage and get with Noelle, if insurance is part of that discussion, then absolutely Jerry gets pulled in, again, part of the complimentary process, and collaborates with Noelle to give you input so those two pieces are connected. I would say take advantage of that. And so Noelle, the question here is, well, I'll just say for Tanya, can you do other professional businesses in an LLC, the engineering consulting business? You would say,
If there are no restrictions on regulatory restrictions, if you have a license or anything like that that needs to be ported over to your entity, absolutely. There's no reason that you shouldn't be doing business in the name of a business entity.
yeah, another discussion there too is for another time, but Noelle, you speak about this too. Our firm does many Plan F reorganizations, converting S corporations to LLCs, taxed as an S, because that's the tax election. Many of those you got to take a look at your business. If you can be an LLC, there is very much a discussion to be had there. Give you a quick example. We're involved in right at this moment. There's the National Association of Stone Cutters across the country, thousands of them that cut stone for personal residences. They're cutting marble and other stone. There is a massive class action lawsuit. This is their new baby. These trial attorneys, they've attacked it. It is happening. We're getting calls. People have 14, 15, 20 lawsuits against them. It's going crazy. And they are very much wanting to put their businesses into LLCs if they're not. So we're doing a crazy amount of Plan F reorganizations for that whole sector. It's happening now. Google it. It's all over California, and it's seeping into other states. So as an example, but all right.
Yeah,
So
and
go
Paul,
ahead.
the distinction I think you're trying to make is, and I don't know that we had time to review it today, is that the corporation, um, as an entity versus an LLC as an entity, the corporation doesn't afford the same level of liability protection because a corporate stock can be taken over, right? Or forced to be given to the creditor. And then as the stockholder, the creditor can liquidate all your assets. Where with an LLC, that doesn't operate in the same way. So if you have an existing corporation, and we do the analysis and we confirm that it can be with little to no adverse consequences converted to an LLC taxed as an S corporation, you're not changing the corporate structure of how it's taxed. You're just changing the entity's structure for liability purposes. And then making sure that we're doing that prior to a liability arising, and making sure that we have that structure ready to go before there's ever a question about litigation, possible liability. So with the example you gave, Paul, maybe they're on the fence yet, like there's a class action kind of pending, but there hasn't actually been a liability to them. So it's a proactive kind of preventative measure, which is fair game.
Yep. Okay. And I know Miriam, quick answer to that. She says, yeah, if you're a California resident, $800 you got to pay to have the LLC. It's true. It stinks. I've got LLCs for my own stuff. It's horrible. It's a money grab in a sense. Other states will charge $100, $50 in the same scenario. So Nicole, I know you addressed this, but quickly, I mean, $800. So if there's multiple LLCs, this is where you have a thoughtful discussion. We realize everybody's got a budget. You don't want to go, crazy, breaking the bank, having to pay the $800 to California, but it is there.
Yeah,
But it's a write-off, right? It's a line item write-off on your tax return, correct?
yeah, it's the cost of doing business essentially, Paul. And I would encourage participants to see that maintaining a properly structured LLC is an insurance on your insurance, right? It's even another line of defense. And being able to say that, you didn't put multiple properties in one LLC is a great thing to have confidence in, because an $800 payment versus exposure of all equity in both of your properties that you're putting in an LLC. That's the discussion we're talking about is, does it make sense from a cash flow perspective and from all other kinds of perspective to treat this other $800 as another liability protection measure? Yes, it stinks that it's just going to the state and they're lining their pockets, effectively speaking, when other states are charging much less. But the FTB, right, Federal Tax Board in California, requires you to maintain an entity in California if you have California real property. I mean, you're doing business in California. So if you want an LLC, it has to be registered in California, in addition to, right, if you have a Wyoming or Nevada or Delaware, whatever we recommend for you. So it's not really optional to not have a California LLC if you want one. If you want an LLC, you have to register it in California, is what I'm trying to say. And so we just know that that $800 is the cost of doing business. You build that into your analysis and see, does it make sense saving the 800 and planning for risk mitigation differently? Yeah. And if we want to couple a few properties in one LLC, what is the risk that you're taking? And looking through specifically to your facts and being open about what you're able to take on administratively and cost-wise. And if you can't do it all at once, that's okay. Start with something and build from there and be able to pivot and grow. It's like if you put 2 properties in one LLC, you can take one out and make an LLC the next year and move it in there. It's no problem. So it's better to do that than to leave, let's say, your brokerage account completely exposed because your rental property was still in your name, right? So they're able to grab that and the brokerage account. Like we want to protect from outside liability. So if the first step is let's just get it into an LLC, and that's what you're comfortable with, and that's what you make an informed decision on with your attorney, fine. It's better than it being in your individual name, so long as we're not being too reckless in exposing the equity of the other properties in there.
Yeah, well said. And I'll just address, Michelle, the basic question: why have an LLC instead of individual name? And you were touching on that, Noelle. And if I just give you some stats again, there's 40 million lawsuits filed in the United States every year, and it's only getting more. Many of those are directed to landlords. Again, we have landlord attorneys. All they do is represent landlords against liability. They are very busy, crazy busy. And, representing all the liability that's coming up, mold cases, just life happening, things happening around the property. So you've got to make a decision as a business owner. You own your rental income property. It's a business. And really, you would never have a business selling widgets where you would own it in your own name versus having it in a corporation or an LLC, a legitimate business over here. But people tend to not look at it the same way with rental property, maybe because they inherited it or human beings are living there. They just don't have the same mindset, and it's a mistake. We just counsel our landlord attorneys, Noelle and others. We just think it's mostly crazy not to have it protected because you have unlimited liability exposure. Hopefully something never happens. If life throws you a curveball, a mold thing, someone gets hurt, a shelf falls off and lands on a kid. We had that come to our firm. A shelf, TV, fell on a baby. It's horrible. Baby was hurt, multi-million-dollar lawsuit. Those things that happen, you are saying, I'm okay walking around, and this could be your choice. It's your choice. It's your business. I'm okay walking around knowing all my cash in the bank, my stocks, my other property, my home is exposed to this curveball over here. If that's the way you feel.
One thing to elaborate too, that Paul, I think that's great the way you described that. One thing to elaborate on with the typical thought process is, well, I have insurance. Why an LLC?
Good point.
Well, the insurance is not on your side. Okay, those agreements are drafted to really fine-tune amount of protection that the insurance company is willing to give you. The reality is that the list of exclusions is far larger than what they're protecting you from. And I would say mold is a big one. Eviction, landlord tenant issues with regards to eviction, not protected. All right, you're just going against the law. The insurance company is not going to protect you from an eviction lawsuit. And in many cases, if it's a mold issue that you had a hand in negligently, they're also likely to not protect you. So a lot of exclusions and exemptions from those insurance policies, and you really don't want to be at the mercy of the insurance company, especially in the current market. You know, they're not your friends. They're not there to protect you. They're just honoring whatever is in that four corners of the document, of the contract. And if the facts slightly skew to be arguably outside of that contract, they're going to argue that. And they're going to pay their attorneys really well to argue that. And so, yes, having insurance is just how you do business. It would be completely reckless if you didn't have it, and sometimes also illegal. But that's not protection. That's just how you do business. And so when we talk about protection, the LLC is really what's affording you that separation of the liability not flowing from inside to outside and coming from the outside to the inside.
Yeah, we've got a great workshop that we do. Again, I can't recall off the top of my head if we've given it to Alexandra here, but it's with our insurance expert, Jerry Connery. Did that with Harry Barth, and Jerry talks about the insurance piece. And maybe we should have him back, Alexander, because as
Yeah.
insurance people are leaving the state, we get a lot of questions, and he's great at telling you how insurance is not going to cover you, unless you do it right, and why asset protection is important.
Yes, we have had it before, but definitely worth linking to it in the follow-up email. Thanks for bringing that up. We could have you all watch the recording, but of course, there's always new things. So I'd love to have them come back at some point.
Okay. All right. I just keep blazing through. We're getting a lot of questions on this area. And maybe we comment here, passing property to the children, Noelle. And I would encourage everyone, we'll still take questions. I want to get this covered a bit here. I'm looking at the questions, I'll save them. But this comes up a lot for us, getting property to the next generation, and just some common, mistakes, benefits, best practices for doing this.
Yes, awesome topic. When we talk about children, we really mean your heirs as well. I mean, there are some tax benefits to passing down to children directly, but you may not have children. So the more generally speaking, it's really how do we strategically transfer wealth to our loved ones if they are children specifically or minors, right? How do we do that in the best, most tax advantageous way, but also from a control perspective? Don't want minors being able to control property or being on title to real property or something mad like that. Of course, we talked about the use of a revocable living trust to transfer wealth. That trust is like a rule book. It just says what you want divided and how, to whom, who's going to control it, at what age would they be able to manage it themselves. We could put in language in there regarding specific use of the property, not selling the property until kids are at a certain age, force selling a property if you think they're going to argue about it, giving some children the rights to first refusal over others because one of them really wants it. So the idea is I'm throwing a lot of things at you because I want you to see that the trust is really like your rule book and you can do anything you think is feasible. If we can draft it properly and there's enough funds to accomplish it, we can do it. And the goal is to reduce conflict. The goal is to pass assets as smoothly as possible. So one of the biggest mistakes is, I think, and I hope none of you are doing this, is just adding your son or daughter on title to your property as a way of them inheriting it. That may be a strategy. It is a tool to pass that asset, but effectively what you've done is you've given them half of the property or more, depending on how you did it, cause a tax reassessment, and it's a taxable gift during your lifetime. And now you've also made the property more exposed because their liabilities can also latch onto the property versus just yours. So lots of unintended consequences where your only goal was, I want to make sure they get it. Why don't I just add them on title? And if I die, they get it. I just explained all the reasons why that's not a good idea. Another mistake would be to, let's say you have the trust, you did great, you put the property in the trust, and you said, okay, it goes to all my children equally. Well, did we consider whether they're going to fight about it? And if it is the primary residence, in California specifically, we have to consider whether they're going to live there as their primary residence because we'd be able to afford their tax savings on property taxes. And so we should build into the trust specific language that says, I want this one child to have, let's say, the property and this other child to be equalizing with cash because I want the child receiving the property who's going to also live there as their primary to keep my tax basis. And that would be under Prop 19 rules. Otherwise, if the trust isn't as clear or if there aren't enough assets to do the equalization, we could end up with a reassessment on the primary residence or siblings fighting against each other or loved ones, not really knowing what you intended. And so the gifting versus the selling, gifting rather versus the inheritance is it's a really important discussion because sometimes it does make sense to gift. Let's say you have an LLC with a really profitable, great business, got an apartment building in there, and you're running a lot of units, and you kind of want out from the property business management side of things, and your adult child, has been stepping into your shoes, and you want to start funneling some of the control their way. You don't want to give away all the control. You want to start funneling some of the income their way. You don't want to give it all away. And so we can start discussing for purposes of business succession, if it makes sense to add them on, and they could be added on as member owners, but not have voting power or something to that effect. We can build that into the operating agreement of how the entity is structured. And then correspondingly, right, build that into the trust. This one child, right, receives the business, all the other ones don't, right? They receive other things and cash values and equivalent. And so building in that is really important to anticipate and avoid conflict, but also decide, well, does it make sense from a gift tax perspective to do some gifting now and then, maintain my income stream and my ability for tax basis, so that then when they inherit it, they're receiving it stepped up in tax basis. They're not receiving it as a gift today with my tax basis. And that's another part of deciding, do we gift now and how much, right? Or do we just wait until the owner passes away, the assets step up in tax basis, and then when the kids inherit them, they're inheriting them at the new basis. So then they could decide, we don't want this property. We're going to fight over it. We're going to sell it day one. Okay, well, if they sell it day one, then there's no huge capital gains. In fact, there shouldn't be any capital gains. But if you gave it to them today or partially to them today, they would pay the gains on the portion that they own because that doesn't step up. So lots of considerations here. The biggest takeaway, Paul, is to prioritize the goals of the client. And I typically just ask them, well, what's your goal? What do you want to do? Oh, I just don't want to manage this anymore. Okay, there's solutions to that. If we do property managers, we could, get your kids in as getting a management fee and having them stepping in, funneling some of the income to them. It doesn't mean you put them on title, right? It doesn't mean you give them everything. You still need to have those assets in your name because they're yours. We don't want to trigger any adverse tax consequences. And then on the inheritance side of things, we make sure the trust says what it should say, with the intention of, again, reducing conflict, making sure everything passes to the right people, with the business in mind, succession in mind.
Yep. No, that's great. I want to address this quick question as it comes up about us working with people outside of California, even though we're headquartered in California. So as I mentioned at the start, we do have 11,000 clients around the country. And this particular individual here is in Colorado. And so depending on what you need done, so we cover it here at our firm, no matter where you're located. If there are local laws that are involved in sophisticated estate planning. For instance, Louisiana still has Napoleonic laws on the books. We do have local counsel that we bring in as part of the team that works with Noelle here as part of our alliance attorney alliance program we have at the firm. So doesn't matter where you are. It all starts, get on with Noelle. If there's something local that needs to be handled, we have the capability of bringing in local counsel if needed. We do that. And then, okay. I want to say to Noelle on this topic, and you can go deep on this because it's an asset protection thing when you're talking about passing property on, but in particular, children. I know you've talked about this, and we do a lot of this. Parents, when they're of sound in mind and body and ready to go, doing their planning, is passing property to the kids in an asset protection trust instead of just having it go to them outright. The parents can set up in their own trust language whereupon their passing triggers asset protection trust. And that's great for kids, special needs kids, your kids. You're fearing they may get divorced and the ex-spouse becomes a creditor and the family assets are then divided with the next. I mean, it gets crazy. So any quick comment on that?
We're a really important topic, Paul, and this comes back to the revocable living trust being your rule book, and that you could design how the transfer of the assets go to your kids. One of the options is it just comes out of the trust. You pass away, they get it, it goes in their name, the trust is done. That transfer process puts the asset into their name. And everything we've been talking about today, something being in your name is exposed to liability and can be grabbed up by a creditor that is up to receive whatever judgment they have against you. So a lawsuit that happens right when you get the asset in your name takes the asset away. So everything your parents worked really hard to achieve, you're expecting to inherit them, and then the assets are gone because they were in your name and the liability hit you, and so those assets are up for grabs. How do we avoid that? Well, there's another option, which is what you mentioned, the asset protection trust. It's not necessarily a separate trust. We don't go anywhere else to create it. We created and anticipate its creation within the parent's revocable trust. So set up a revocable living trust with language and rules about what happens after you die. And instead of it saying the assets go outright to my kids, it say that assets stay in my trust for the benefit of my kids. And specifically, a subtrust per child typically is how we set it up. And it could be a lifetime subtrust. What does that mean? It means that they inherit you inside of your trust. They'll have their own trust with its own tax ID. And we could set it up so that they're in control or another trustee is in control, but they're the beneficiaries and they can demand the assets come out if they need them. Otherwise, they could stay in the trust, be an investment vehicle for them that is not only legally separate, but physically separate from everything else they're doing. Marriage, divorces, businesses, lawsuits. And then in the trust itself, we have language that says the trust assets are protected from creditors. Creditor can't come in and force the asset to come out through bankruptcy or liens or any other ways, and can't force the beneficiary to assign their interest out to them. So really strong asset protection language. If we can get somebody else's trustee, it makes it even stronger. And that can be a separate income producing investment vehicle for them that is available for their lifetime. And then we also build in, well, what happens if they pass away and there's still money in the trust? We have language for that too. So it becomes a multi-generational asset protection trust, which you're setting up through your revocable living trust. And Paul, I don't charge any extra for this. That's actually what I recommend for a lot of my clients. I may charge extra, but I don't want to say that. But it's typically speaking, it's within our wheelhouse. Is what we do all the time. We're experts in this. We take the extra effort. I specifically take the extra effort to recommend this to my clients because we are an asset protection firm. I mean, it's a huge issue if we just say, yeah, we'll just do it outright. It's not a problem. No, it is a problem because we know that we've worked so hard to get the assets up until this point. once our client passes away, those assets are gone. They're up for grabs. Why would we position you to be not an advantage in the future and position your family to potentially have these assets grabbed up pretty quickly and sometimes
Yep.
without their intention, you know? It's not
Yep.
that they misuse them. It's not that they you don't trust them with it. Like that's a different issue. We can plan for
I
that.
got 4 kids and I don't trust any of them.
Yeah, we can plan for that. That's not a problem. We're talking about just the way the trust is drafted. It just says the assets come outright. You trust your child, you love them, you know they mean well, but they can get sued for something that they didn't want to be sued about, right? They had nothing to do with it, or they just to litigious society, it just happens, or you know they get divorced or whatever, and now these assets are up for grabs and commingled, and there's arguments
Yep.
back and forth about all of that. So we want to avoid that, and we can avoid that. Just be more intentional about how the trust is drafted.
Well, here's a question related to that. That's great. And David, yes, this workshop will be available to view later. Alexandra is getting it out, the recording to everybody. How do you transfer a portion of a property to kids over the years until reaching 100%?
The ideal way would be to have it in an LLC and then gift the assets over time through an assignment or gift of membership interest. And that has to be worked into kind of a reassessment analysis as well. And it has to be analyzed through the lens of gift tax planning and just making sure we're doing that properly and getting the right appraisals and everything. We also don't want to trigger a lot of change of ownership issues if we don't have to with regards to reassessment. So we would advise, depending on how you want to do it and why you want to do it, the most ideal way would be through the LLC itself, assigning membership interest over time, because that way you don't have to worry about the deed, right? The deed stays in the LLC. It's the
Oh,
interests in
yeah.
the LLC that are changing.
Yeah, which is great. It's another benefit I've heard you talk about with LLCs is this whole idea of including the kids in the business, getting the property to them in a scalpel-like approach, looking at the tax ramifications, the kids and what they're doing. Yeah, I love hearing about that. Uh, okay. Oh yeah, Alexander's responding there. Yes. Can I have your contact information?
Well,
Yeah.
and sometimes, Paul, it doesn't have to be an LLC, right? It could be like a family partnership, or we could do a partnership with gifting trusts. I mean, there's all kinds of ways to accomplish it, but what we want to avoid is just real property, title of real property, splicing it up that way. We want to make sure it's in some protected entity, whether it's a partnership or an LLC, and then designing it so that the structure is protected. And if we want to make a gift, again, we don't have to just give it to them outright. We can give it into a gifting trust, an asset protection gifting trust for their benefit. And so we can really level up on the asset protection piece, even with current gifting. And that's not something that would be advisable to every situation, but it's definitely something that's on the table.
Okay, and I just put up, Diane asked for my contact information. This is how to get a hold of me, my email. That's my direct line. Call me, email me there also. And I did put the link back up there to get connected. Okay, Noelle, so here we've got probate. And maybe just a quick touch on why this matters.
Probate is a necessary but avoidable process. Okay, so it's a court process that transfers title of assets from somebody who's passed away to wherever those assets should go. If you have a will and it says, I want my stuff or my assets to go to my cousin, my aunt, my sister, my brother, my kids, whatever your intentions are, that typically goes in the will. But the will doesn't avoid probate. The will just gets submitted to the probate court judge who looks at what you preferred and decides, okay, let's go through the process, slams a gavel, and then those assets transfer. We want to avoid that process because probate is a public process. It is a court process, so you typically want an attorney. And as much as I'd love to be hired on the probate side of the administration, I don't think it's ideal for the family. And I think it's too costly. There's statutory fees that get paid to the attorney, statutory fees that get paid to the executor. Now, the executor could be someone that you've chosen in advance in your will, or somebody that the court appoints that could be a family member. But it's a lot to ask of them, right? To just step in and go through this process, which could take anywhere from 18 months or more, sometimes 3 years. And that means that your assets are stuck in probate court under the jurisdiction of the court and the supervision of the court. Yes, the executor can make some decisions over them, but nothing transfers until the end of the probate. In other words, the inherited assets are not, even though legally they're vested to be inherited, they don't actually transfer hands until the end of the probate. That's bad news for an operating business. That's bad news for a primary residence. We don't want things up in the air like that. And not only is it public and expensive and time consuming, it's just difficult and hard and a lot of red tape to go through, and the family's confused and everybody's not understanding why nothing was prepared ahead of time because it's avoidable. How do we avoid probate? We make sure that there's nothing in your name to pass through probate. In other words, you're not on the deed to your house. Your trust is on the deed to your house. And if that's the case, then automatically your trust is the owner, the trustee is the manager, the trustee after you steps in to manage the assets for your loved ones. It's as simple as that. There's nothing subject to probate. Nothing goes to the court because nothing's in your name, right? You might have a bank account, you could put that in the trust, or you could put the trust as beneficiary. We don't want any assets subject to, right, the court process, which means if it's in your name and not under the authority of your trust or not automatically passing to somebody else as a beneficiary, then someone like a probate court judge has to transfer that asset via court order. Otherwise, nobody can transfer it. And so it's a necessary process. Thankfully, we have it, but we can avoid it, especially in California. It's very cumbersome. Other states, not too bad, but also avoidable. You also don't want to just be stuck with whatever the probate court judge decides as applying the probate law on who automatically gets your assets. So if you don't leave a will, at least, you're not telling the probate court judge what you want. And so it might go to whatever the probate code says. It could go to your spouse directly. It could be split between your spouse and your kids. Some states require that. That's not maybe not what you want. Maybe you want it all to go to your spouse, and maybe you don't want that at all. I don't know. So having the trust is important to dictate exactly what you want and manage it over time. Probate court is assets get divided, distributed, we're done. So there's no ongoing management for minors. There's no asset protection, anything. It's just a way to transfer title. That's all we're doing. And so it's a very unprepared plan for business and wealth succession.
Got it. Some good questions here related to this area. How can you do, this is Frank. Thanks, Frank. How can you do a 1031 with property titled in an LLC in a one-person LLC without taxes on the one person?
So my understanding, and we'll have to confirm with the CPA, but 1031 exchanges link back to whatever the social kind of security number is of the owner. And so with an LLC, if it's taxed through to the individual owners, so typically disregarded. If it's a single member LLC, the form that you'd be submitting to the IRS would be that the associated social security number is the owner, so that the actual living person and not the LLC itself. If the LLC does have its own EIN, obviously, but for tax purposes, it's still going to the individual owner. And so with a 1031, my understanding is that the sale and the acquisition of the new property has to be the same person or the same tax ID. That's what should be utilized when the exchange is happening. Now, if it's happening within the LLC, like the LLC is selling a property and then the LLC is also buying that property, I don't see why that's confusing unless maybe you're using another LLC to buy the other one.
Yeah, and
Then
I'll
you,
say, I was just going to say here too, Noel, that
yeah.
to Frank, is that as people bring up these issues and when we're looking at things, so we do have a tax attorney. We also have CPAs that are part of our alliance at the firm. So for us, it's a collaborative thing because like when you're making decisions about one planning area, they very well could impact other planning areas, estate planning, tax, asset protection. So Noel's great at quarterbacking that, bringing in the people as needed, and tax is one of them. Um, Sam's asking, mom passed away and had two properties, how to establish her estate. I'm not sure I understand that. Maybe you have a better feel for that question.
First of all, I'm very sorry to hear that. To
Yeah.
lose the parent, but also, having the properties, not knowing what to do with them. If mom passed away without a trust, then the estate is subject to probate court process. And so that process has to be completed first before there could be any kind of transfers and further planning on those assets. And the particular heirs receiving those assets. So that's really, I think, subject to probate. Her estate, it doesn't really get established. It just exists and now needs to be administered or managed. And if there was no trust, then the only way to do that process, that management process, is to petition the probate court to begin a probate for her estate in the county that she passed away in.
Okay, how to change the deed of the property to the joint ownership? Does that make sense to you?
Yeah, any change of deeds can be done through an attorney. It could be done through a title company. Um, a change of a deed, who's on the actual owner or taking title, is the owner of the property. And so you want to make sure you're making an informed decision about adding somebody or removing somebody, especially if you're married, right? That could trigger other requirements to notify your partner of what's going on if it's a purchase of another property with somebody else. The reality is it's just a deed. You create, either you can do it. I think the counties have their own kind of form deeds you can do. I don't recommend that. You could work with an attorney like our office. We're happy to help with that and make sure that fits into the overall plan, what you're trying to accomplish. And then it would go from the original owner, would be the grantor, to the grantee. So the new owner would be the joint owners. So the owner gives it to the owner and the other owner that they're trying to give it to. But that process it's a reportable event. If it was gifting to somebody else, it's a property tax potentially reassessable event. If it's gifting to somebody else or changing ownership to somebody else. And depending on how you do joint owners, it could be joint tenancy or joint tenants in common. So those are two different things. And depending on your goals, we need to talk about how we do that.
Okay. Uh, Someone asked for a website address for us. I just put it in the chat, and you're lucky because we just launched our brand new website 2 days ago. So we're loving it. But yeah, go check us out. You can see everybody up there, me, Noelle, everybody else at barthattorneys.com, BARTH, attorneys, plural.com. I just put it in chat. Thanks for asking about that. Cassini Group LLC. They have an LLC. Great. Noelle, if you have a POD on a property or bank accounts, does it go through probate?
So pay on death, PODs stands for pay on death, is a term that indicates or tells us that that account has somebody already in line to receive it if the account owner dies. Typically for like a bank account, one person owns the account with a beneficiary ready to go. it pays on death to that beneficiary. Those accounts are not subject to probate because we have a home base for them. It's the beneficiary. Now, if there's a question mark about that beneficiary, if they passed away, it would go to their estate or maybe not, then that account might be subject to probate. With real property, though, Paul, I find that using a pay on death type of deed, they can be used, but they have problems with them. They're not automatically going to be enforced. There's still a notice period. You still have to make sure that the deed was properly signed and notarized and all the formalities were followed. So there could be issues with the real property transfer via pay on death. And also it doesn't anticipate anything further than that. So what if one of the people you want to pay on death to for a real property is no longer around, right? Or they're incapacitated or they have special needs. It's like it just doesn't plan for anything further beyond just
Oh,
I die, it goes to these people. That's it. So if one of them died, depending on how it's split up or gifted to them in the pay on death arrangement in the deed itself, that could be subject to probate even then. So yeah, it's a solution, but it's not the best one, and it's not as commonly used anymore, especially in later years where California, at least, I don't know about the other states, but have more stringent requirements regarding notice to the heirs, about a 120-day waiting period. And so it's not automatic. There's still some kind of process that still has to confirm, hey, did this person just sign it? And were they unduly influenced, right? Did somebody
yeah.
put a gun to their head and make them sign it? So it's not a guaranteed process. It has its own formalities for there to be marketable title, and so that then that the people on the pay on death arrangement can receive the property free and clear without all these issues in it.
Got it. B Torp is asking, I have a privately held corporation with property in it. Can a beneficiary be named to get the company and assets?
So, from what I'm understanding, there's a corporation with a prop beneficiary is the owner, and then there is some kind of entity agreement, whether it's bylaws or a shareholder agreement about how assets transfer if the stock owner passes. And so sometimes it says in there, I dictate that it passes to these specific people. That's fine. Typically, it would just go to the estate of the stock owner, and then we're back in kind of probate / trust land, depending on where we did the planning. But there isn't like a beneficiary form or anything like that. You could potentially do an assignment of stock ownership, so long as it follows the formalities of your corporation.
Okay.
Um, I would advise to, yeah, dig into that deeper and just make sure that the operating agreements follow the intent of the succession.
Okay. And probably one of the last questions here as we're getting kind of, oh, we've gone a little over. Great. Love it. But we have this Mark, thanks. We have a holding company, LLC in Wyoming that owns a rental property, LLC in a Kansas LLC. We are flipping properties in Florida. Can we hold the properties in our Wyoming LLC, the holding company, while using another Wyoming LLC registered in Florida to market and sell the Florida properties? And
I
that
think I'm following.
could be an offline question for Mark to
It
get
could
one
be an
more idea.
offline question. It could be an offline question, but let me try and break it down. So, based on what you've shared, if I'm understanding correctly, the initial Wyoming company that's holding the Kansas LLC that's holding the rental property, it sounds like it's operating as a holding company. So it sounds like to me, it's operating as an entity that owns other entities for purposes of asset protection. So I wouldn't take a rental property and fund it directly under the whole Wyoming holding company. Um, and I don't think that's what you're asking. I think what you're saying is, can I set up another Wyoming company and flip Florida properties? I don't see why that would be an issue. But there may be something lost in translation here, so we're happy to dig deeper into that in a one-to-one.
Okay, great. Mark said yes. Uh, Cassini, question is, thanks. We're considering setting up an estate planning or living trust for our rental properties to pass on our adult children. Do you offer some phone consultation prior to us coming to visit you? You don't even need to come to visit our office. And so, technology today, we do a lot by Zoom, phone calls. And if you reach out to me, there's a link in the chat. I will put it, well, here, I'll put my email again right after your question, Paul at BarthAttorneys.com, and I will get you connected to Noelle. And so just email me there. You can get on a phone call or Zoom, complimentary, leave the checkbook at home. Happy to do that. You'll get into the weeds with Noelle on your own planning. A lot of times we have an intake form online that you fill out, a few minutes about what you own, how it's titled. So Noelle can really give you some value on that call based on what you have. You get on there, and then we stand ready to help you from there if you want us to. Whatever you talk about with Noelle to go forward. So, uh, okay, so Alexandra, what are you thinking here? I've got yeah, there's the link she's putting in the chat. Yeah, we love this. You got to have us back because we could keep going here forever. Noelle, we love it.
Good, good. Well, we love it too. So I'm glad that we went through so many questions. I know there's probably some we didn't get to. So I'll try to send what I can over to you, Paul, to follow up with anyone that we
Right.
didn't answer. And then we will always, as usual, provide everyone with the recording tomorrow, maybe sooner. We'll see what we can do. And of course, the contact information and link for the consult will also be sent in that email, as well as any slides. And hopefully you'll get a chance to connect with BarthCalderon and their team in some capacity, because it really is a great step towards making those plans and making sure you have all your questions answered specifically to your situation. So with that said, I thank you all for sticking around for so long. As usual, we always go over time, but I'm glad we still get plenty of people to keep asking questions. It's really important for us to keep learning. That's why we have these webinars and why we have such great guest speakers who can teach us a lot about what we don't know. I always learn something new myself, even though I'm on every webinar, obviously. So thank you for that as well. And as you're exiting, please take the exit survey. We are trying to get to know our members a little better and see what benefits might interest you. We have a few ideas for things we want to add. So go ahead and put your vote in there and let us know what you want, and we'll get working on it. So in the meantime, I hope you all have a wonderful day. And thank you, Paul. Thank you, Noelle, for a fantastic session. We really appreciate it.
Thank you,
Thank you for
Noelle.
having
Yeah.
us.
Yeah. Thanks, Alexander. Thanks.
Thank you.
Thanks,
All right.
everyone.